Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 creatively imagined scenarios involving the great painter, Van Monet, to examine vitiating factors in contract law, a key topic in FLK1. Let's dive into the fascinating intersection of law and art. An elderly, world-renowned painter known as Van Monet is in declining health and under the daily care of a live-in caretaker. Over time, the caretaker frequently praises the painter's artworks and repeatedly suggests, subtly but persistently, that it would mean a lot to her son, an aspiring art lover, to one day own some of Van Monet's paintings. Eventually, the painter executes a deed of gift transferring 3 valuable paintings to the caretaker's son. After the gift is made, Van Monet's close friend and confidant becomes concerned and encourages him to seek legal advice. Van Monet now wishes to challenge the validity of the gift. Can Van Monet bring a claim for undue influence? A. No, because the caretaker's son, not the caretaker, received the gift. B. Yes, because there is a presumption of undue influence in relationships of trust and dependency. C. No, because the painter signed the deed of gift freely. D. Yes, because the caretaker used unlawful threats to procure the gift. E. No, because the gift was made to someone who genuinely admired the paintings. The best answer is B. Yes, because there is a presumption of undue influence in relationships of trust and dependency. This scenario involves presumed undue influence, a doctrine that protects vulnerable individuals who place trust and confidence in another person. The relationship between a frail, elderly individual and a living caretaker is likely to fall into a category where undue influence is presumed, a Tridge case. Even if there is no direct coercion or overt pressure, gifts made in such circumstances may be set aside unless the recipient can rebut the presumption by showing that the donor made the decision freely and with full understanding, usually by demonstrating independent legal advice. Here, the caretaker's repeated suggestions, combined with her position of influence, support a possible claim of undue influence, even though the gift was made to her son. Scenario 2. A young man attends a seminar hosted by a company selling paintings by the artist Van Monet. The seminar is engaging and informative. He genuinely enjoys the event and finds the artwork inspiring. He is particularly impressed by the speaker's claim that Van Monet had been a student of both Van Gogh and Claude Monet, which adds prestige and artistic value in his view. Motivated by this information and seeing it as a promising career opportunity, he signs an agent agreement and pays a fee to become an authorized seller. He successfully sells several paintings and earns commission. Later, he discovers that Van Monet was never a student of either master, and is entirely self-taught. Feeling misled, he now seeks legal advice. What can he do in these circumstances? A. He cannot take legal action because he signed the contract willingly and profited from it. B. He can only bring a claim if he returns all commissions earned. C. He can rescind the contract and keep the commissions earned. D. He can sue for breach of contract due to the misrepresentation. E. He can claim misrepresentation and seek damages, but rescission may not be available. The best answer is E. He can claim misrepresentation and seek damages, but rescission may not be available. The situation involves a misrepresentation of fact, specifically, that Van Monet had studied under Van Gogh and Monet. The young man relied on this false representation when deciding to sign the agent agreement. This is likely a case of negligent misrepresentation under Section 2(1) of the Misrepresentation Act 1967, unless it can be shown that the person making the statement honestly and reasonably believed it was true. However, because the man has affirmed the contract by continuing to perform under it and benefited from commissions, the remedy of rescission, which aims to return both parties to their pre-contractual position, may no longer be available. Courts are unlikely to allow rescission where it would be unjust or impractical due to affirmation or change in circumstances. The young man may still claim damages, calculated to put him in the position he would have been in had the representation not been made. Scenario 3. A solicitor is consulted by a sales agent who exclusively represents the artist Van Monet at a prestigious art gallery. The agent's income depends significantly on commissions from selling Van Monet's paintings under an existing agreement. While negotiating a new sales contract, Van Monet threatens to withdraw all future consignment of artworks to the gallery unless the agent agrees to waive a claim for unpaid commissions owed under the prior contract. The sales agent seeks advice on whether he can pursue a claim against Van Monet for economic duress based on this threat. How should the solicitor respond? A. Yes, as the agent had no reasonable alternative to dropping the commission claims. B. No, as the agent had a reasonable alternative to dropping the commission claims. C. Yes, as Van Monet's position is likely to amount to illegitimate pressure. D. No, as Van Monet's position is unlikely to amount to illegitimate pressure. E. Yes, as the agent's business relies heavily on continuing to sell Van Monet's artwork. The best answer is D. No, as Van Monet's position is unlikely to amount to illegitimate pressure. This scenario is governed by the principles set out in Pakistan International Airline Corp against Times Travel. In that case, the Supreme Court clarified that lawful act economic duress requires more than mere commercial pressure. The claimant must establish 1. There was pressure amounting to illegitimate conduct. 2. That pressure induced the agreement. 3. The claimant had no reasonable alternative but to give in. In the present case, Van Monet's threat to withdraw future paintings is commercially tough but not necessarily illegitimate. Artists and businesses are entitled to negotiate from a position of strength and impose conditions when entering new contracts, provided they do not act in bad faith or use unconscionable tactics. Unless Van Monet used reprehensible means or engineered the sales agent's vulnerability to extract the waiver, the court is unlikely to find economic duress. This table summarizes the key legal principles we have gone through today. In certain close relationships, like between a carer and an elderly person, the law recognizes that one party may naturally have more influence over the other. If the weaker party gives a gift, the court may assume that it wasn't entirely their free choice. This is called presumed undue influence. Unless the person receiving the gift can prove that the giver acted independently, usually with proper legal advice, the gift can be set aside. The law steps in to protect vulnerable people from being quietly pressured into parting with valuable property. When it comes to misrepresentation, the law protects people who enter contracts based on false statements. If someone says something untrue that convinces another person to sign a contract, the person who relied on that statement can usually claim compensation, even if the statement wasn't deliberately false. That's because the law assumes the person who made the claim should have checked the facts first. However, if the misled person carries on with the contract and benefits from it, like by earning money or continuing to work under it, they might lose the right to cancel it, though they can still ask for damages. Lastly, economic duress deals with pressure in business deals. Not all pressure is illegal, people are allowed to negotiate hard. But if one side uses illegitimate pressure that leaves the other party with no real choice, then the contract could be challenged. For example, threatening to cut off business unless someone gives up a legal right might feel unfair, but unless it crosses a legal line, like using bad faith or exploiting serious vulnerability, it usually won't count as duress. Courts are cautious, they won't undo contracts just because one side had more power. Do you enjoy these imaginative scenarios while studying for the SQE, and realize how English law is all around us? Passing the SQE can help you achieve your goal of becoming a solicitor, and it also trains us to think critically, live wisely, and recognize potential pitfalls in everyday life. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.